Hi everyone, welcome to the 2020 Rothgerber Moot Competition Final Round. My name is Emily Horowitz and I'm the Program Director for the Shadden Experiential Learning Program. In 1951, Ira Rothgerber Jr. established this annual appellate competition at Colorado Law in honor of his father, Colorado Law graduate Ira Rothgerber Sr. We thank the Rothgerber family for their unwavering support and programming at Colorado Law, which includes this moot court competition and the annual Rothgerber Conference, which will take place remotely on Friday, April 3rd. For over 60 years, Rothgerber has been the premier moot court competition at Colorado Law. This competition provides our students with an opportunity to showcase their outstanding appellate advocacy skills. We congratulate this year's finalists, Sandhu and Paul Chin, who will argue on behalf of the petitioner, and Danielle Trujillo and Asia Robbins, who will argue on behalf of the respondent. We wish each of you luck in today's argument. 21 students competed in the preliminary round of this year's competition. We congratulate all of our student participants. Part of the rich tradition of this competition is also the distinguished panel of judges that we assemble each year. We are honored to have 3 outstanding jurists with us this year. The Honorable Allison H from the United States Court of Appeals for the 10th Circuit, the Honorable Jaclyn Brown from the Colorado Court of Appeals, and the Honorable Richard Gabriel from the Colorado Supreme Court. We really appreciate everyone's flexibility in light of the situation, and we give a special thanks to Justice Gabriel for helping us make arrangements to use the courtroom at the Colorado Supreme Court. We look forward to a great final round and thank everybody who is joining us remotely today. Good luck, competitors.
Thank you.
Go ahead, or you go ahead, Amber.
Oyez, oyez, oyez. All persons having business before the Honorable the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now in sitting. God save the United States and this honorable court.
Well, welcome, ladies and gentlemen.
Welcome, competitors, finalists. Our congratulations to all of you as well, and welcome to everybody who's joining us on remotely through us. I don't know if this matters. My name shows as Amber on here, but you're much better looking than I am, so we're good. Anyway, welcome to everybody. The court will call the case of William Bohemia versus Nicola, Magnussen and Doyle Media Inc., case number 40-001. As I understand the way the argument will proceed, we're going to hear issue 1 first from each side. So the petitioners will go first. They have 13 minutes, and the respondents will take up issue 1. They have 15, and then the petitioner will have 2 minutes for rebuttal. Thereafter, we will turn to issue 2, and we will commence the same process. If that's acceptable to everyone, it looks like it is. I think we're ready to proceed. I think, Mr. Sandhu, you're first. If so, the podium's yours. Please proceed.
Chief Justice, and may it please the court. My name is Sandhu, and along with my co-counsel, Paul Chin, will be arguing for the petitioner in this case. The question I will be answering is whether the domestic relations exception applies to the federal question statute. It does not for 2 reasons. First, because Congress has never intended the exception to apply to the federal question statute. And secondly, even if the exception is not per se inapplicable, the remedies sought by petitioner in this case are not the sort considered by the exception, nor would its application here serve the purposes of judicial expertise or logistical practicability. First, congressional intent. It is well understood that grants of statutory jurisdiction, that is subject matter jurisdiction, cannot be enlarged nor constricted by this court. That is something left for Congress. As this court stated in Marshall, and as is undisputed here today, this court has no more right to usurp jurisdiction which does not belong to it than to disclaim jurisdiction that does. Now, the Barber Court, when it invented the exception in dictum without citation to authority, may have strayed away from this.
Let me just stop you there. So you use the word invent
On purpose? Tell me what you meant by that.
That word is actually taken Aiken-Brand Court decision. The reason the Aiken-Brand Court decision used the word invented as opposed to found or otherwise reasoned is that the principles relied on by the Barber Court went unknown to the world. The Aiken-Brand Court only found reasoning in the dissent in Barber. Now, the dissenters believed that some language of the then existing diversity statute evinced some sort of congressional intent to limit our court system in a way that somewhat mirrored the ecclesiastical chancellery divide of the English courts. However, after explaining this faulty perfunctional historical analysis that existed in the dissent, the Aiken-Brand Court made clear that it was not resting its reaffirmation of the exception on the historical analysis of the dissenters. Rather, it was doing it as in line with the principles of this court by resting it on congressional intent. Their theory, the theory that should be adopted by this court today, is that Congress was put on notice that this court understood its jurisdiction to be limited by the exception. They were put on notice of Barber and for the 150 years after these cases. And after 4 attempts and 4 successful tries to change the diversity jurisdiction statute, Congress never intended to remove the exception from the statute. Nothing in the text nor underlying historical analysis of the legislative history evince any congressional intent to remove the exception.
Let me ask you, Mr. Sandhu,
The language of both the diversity statute, at least at the time, and the federal question statute was the same, was it not? It said at common law and in equity.
It's important to note that when the diversity statute, the first diversity statute was invented in 1789, there was no federal question jurisdiction.
right, but the language was the same when they adopted federal question jurisdiction, was it not?
It was.
All right, so why would, well, there's 2 questions. Why should we interpret federal question and diversity statutes, the language in both of them differently? That's number 1. And number 2, if, as you say, the diversity statute, the federal question statute was later, then why don't we assume Congress intended it to have the same meaning as the federal question statute? I'm sorry, the diversity statute.
Your first question, but also just as a head note, it's important to recognize the in common law and at equity language exists in neither of the statutes to this day.
No, I understand that. So get to answer my question. Why should we construe that language differently?
First, the similarities in language, and just to clarify your question, are you talking about the similarities that exist today or the similarities?
No, before. Today it also is all civil actions, I understand that. But your argument is that the legislature intended diversity jurisdiction to have this exception, and it was based on a common law and inequity. So whatever many years later, the federal question statute is adopted has the same language. Your argument is that it should have been interpreted differently, or that Congress intended something different. I'm not sure I understand why.
For 2 reasons. First, the original analysis done by the Barber dissenters has been discounted by this court. There is no clear understanding, in fact, the opposite, that the language in common law or at equity would actually give rise to this exception. Now, the second reason is that it is clear the Aiken-Brand Court never tied the exception to that specific language. The Aiken-Brand Court thought Congress would put on notice not from 1 line or 5 words of the statute, but on the court's understanding of jurisdiction in diversity cases as a whole. To give a clarifying example, this court removed the in common law or at equity language around the 1940s. Now, if the exception was in fact tied to that language, then surely the removal of the language would kill the exception wholesale. But that was not the understanding of the Aiken-Brand Court, and it's not been the understanding of this court in the years since Aiken-Brand was decided. Now, clearly, Congress was put on notice, or that the exception applied to the diversity statute, and thus their silence was tacit endorsement of the status quo. That is the exact opposite in the case of the federal question statute. Congress was put on notice that the exception did not apply for 3 specific reasons. First, because this court has never applied the exception to a federal question case. Secondly, because jurists on this court have repeatedly said in no unclear terms that the exception is inapplicable to the federal question statute.
But what do we make out of the fact that they adopted, when they enacted the federal question statute, they used the exact same language?
That would be salient to this court's analysis if Congress had understood the court to best or plant the exception in that particular language. It didn't. It was put on notice because of the court's general understanding of how far its diversity jurisdiction would extend. Surely there are other canons of construction that Congress will understand this court to invoke in construing or understanding its statutes. This exception wasn't rested on the basis of the text and text alone, or rather a broader understanding of diversity jurisdiction. Now, the third sort of news that Congress had the benefit of understanding when they revised the federal question statute is that the vast majority of circuit courts have adopted the rule that we asked this court to adopt today, that the exception is per se inapplicable to the federal question statute. Now, armed with these three sorts of notices, over the last 150 years, this Congress has never provided any intimation, nor much less any clear intent to apply the exception to the federal question statute. And thus, their silence on this issue is the same here as it was on Anchorage. Tacit endorsement of the status quo. There is simply no act nor omission, no other language from Congress to tell this court that it ought to constrict its subject matter jurisdiction in cases arising under federal question by applying the domestic relations exception.
Well, counsel, can I just ask you, I mean, you know, Mrs. to be true that somewhat dangerous to read anything into congressional inaction. There are all sorts of reasons why Congress could be silent. They just don't want to act. We don't really know. And do you think we do know?
I think that if congressional silence is to mean anything in this case, it is that it should be tacit endorsement of the status quo. But I recognize your point, and it's a hesitation that this court has been faced with time and time again. However, their silence, if it is not to mean the endorsement of the status quo, can surely not be read as a transplant of a jurisdictional exception to an entirely different federal question.
Well, maybe it just doesn't mean anything.
If it is to mean nothing, there's nothing else in congressional history, whether it be the legislative history or the direct text of any statute they passed, to show that they intend that this apply. Now, even if it's not to mean anything, there are prudential reasons that this exception should not be extended to this federal question case. The first among them is the Constitution itself. The Constitution is a counter-majoritarian check on democratic access. If we are to take the Constitution and the protections embodied in 1983 and fully push them upon state court judges, like the judges in this case, this court would be asking democratically elected judges to guard against democratic excess. In the case of this particular case, the judges have close relationships with the institutional actors against whom they're supposed to be guarded. It is clearly outside of the purpose of the Constitution as a whole to push these cases upon the state courts. Now, even if this court is unwilling to adopt the per se rule of inapplicability, the remedies sought by petitioner in this case are not the sort considered by the exception. When the exception does apply, it only considers the issuance of a marriage, divorce, or child custody decree.
Well, tell me what the rule you would adopt on that. Is it strictly, it only applies if it's a divorce decree or a child custody decree, but it doesn't matter if it's maybe related to the decree?
Where's the line?
The line has already been drawn as well, but we really hope that they adhere to it. This court had put forward an anchor grant that the enforcement of such decrees is well outside the bounds of the exception, and thus the jurisdiction, this court has proper jurisdiction. Furthermore, this court has shown via cases like Loving and more importantly, Obergefell, that just because an action taken by this court would affect jurisdiction or would affect the issuance of such decrees downstream, doesn't mean it's within the bounds of the exception.
Counsel, can I just ask you just to clarify? So you're saying we don't have to decide the main issue here. We can simply say, in your case, right? And is that what you're arguing for? We don't have to decide broadly. We can say in your case.
No, Your Honor. We're asking you to confine the exception to only the strict interpretation of it, which is the issuance of a marriage, divorce, and child.
Okay, so you are asking for a very narrow interpretation.
Yes, Your Honor. We are asking this court to adhere to its previous narrow interpretation. Now, a child custody decree comes with two main things. It vests in the holder's certain rights, and it concerns a specific child. The fit and proper person certificate we ask of here, we ask of the district court, does not concern a specific child, doesn't name one on the face, and it doesn't even guarantee that a specific child will go up for adoption. Now, outside of this big difference, it doesn't vest in the holder any particular right, not the right to control the upbringing of a child, like the child custody decree, nor the right to act as a third party to rectify wrongs done to the child, as a child custody decree would. Because this fit and proper person certificate does not function in any way similar to a child custody decree. It is certainly not one. And we ask this court to confine the interpretation of the exception, when it does apply, to the decrees it has already said it applies to. Now, finally, there is no purpose in applying the exception.
So, I'm sorry, let me ask again on the decree. I'm still not sure how limited
Different states call decrees different things. Does it have to be a document that says child custody decree and that's it? Or what?
We're not asking for rules so formulaic. All we're asking for is that the final vesting instrument be the one that's considered a child custody decree. As the record makes clear on page 9, there are other documents that an individual has to seek in order to receive a child custody decree, even for the purposes of adoption in the New York
But the
State
order
law.
that you're asking for is essentially a precondition to a child custody decree, is it not?
It certainly is, Your Honor.
And so are those issues intertwined? I mean, if it is one step on the process toward getting to a child custody decree, where do we draw the line between what very well may be preconditions or initial steps toward obtaining a custody decree and the moment we get a custody decree?
The final line should be exactly as Your Honor said, at the moment an individual gets a child custody decree. And this is borne out by case law. As in Obergefell, when an individual filed in district court hoping to strike down the law that precluded them from being married to a person of the same sex. That law was itself a precondition, something that individual had to bypass in order to receive a marriage certificate. Now, I'm almost out of time here, if I could briefly conclude.
in one sentence or so?
For these reasons, we ask the court to reverse the 14th Circuit and remand this case to the United States District Court.
Thank you, Mr. Sandhu. You have 2 minutes for rebuttal. Ms. Robbins, I believe you first.
Honorable Chief Justice, and may it please the court. My name is Asia Robbins, and today I represent Respondent on Issue 1, whether or not the domestic relations exception applies to federal question jurisdiction. My co-counsel, Danielle Trujillo, will be representing respondents on Issue 2, whether or not the actual malice standard applies to limited purpose public figures. This court should affirm the 14th Circuit's determination that the domestic relations exception applies to federal question jurisdiction for 2 reasons. First, the statutory scheme adopted by Congress precludes inferior federal courts from exercising original jurisdiction over all matters concerning the issuance of a divorce, alimony, or child custody decree. Second, applying the exception universally across subject matter jurisdiction serves important federalism values such as parity, democratic accountability, and effective resolution. Because the relief that petitioner seeks is for all intents and purposes a child custody decree under the meaning of Aiken Brand, this case falls within the purview of the domestic relations exception and should be dismissed for lack of subject matter jurisdiction. Regarding my first point, statutory grounds limit the jurisdiction of inferior federal courts when considering matters concerning domestic relations.
So you can see the exception is statutorily based, right?
Yes, Your Honor.
All right, so didn't Aiken Brandt make clear that the exception came from the statutory construction of the diversity jurisdiction statute?
Yes, Your Honor.
And so how then do we get to it also applies to the federal question statute?
Your Honor, when analyzing the statutory construction adopted by the Barber Court of that key language at common law and inequity, it becomes clear that Congress intentionally included that language in its initial grant of federal question jurisdiction in 1875, just 17 years after Barber was decided, where the court unanimously considered that key language at common law and inequity to be preclusive terminology that limited the jurisdiction of inferior federal courts when considering the types of cases that would have been heard by the ecclesiastical.
So what do we do about the current language? It says all
Civil actions. Congress got rid of all of this language about it, common law and equity.
Your Honor, respondents argue much the same as petitioner, that the exception exists partly as a matter of implicit congressional ratification, but also respondents point to that key language and the statutory construction of the Barber Court, which was then adopted by Aiken Brandt as an anchor for the exception. Petitioners try to base the exception in thin air, argue that it comes from mere silence. However, there is strong precedential hook for the exception to also exist in the capacity of federal question
So
jurisdiction.
did we not have jurisdiction in Troxel and Obergefell and all these cases that clearly related to domestic relations law?
Your Honor, that brings me to an important point, which is that the rule that respondents are asking this court to adopt is that the domestic relations exception should apply to federal question cases and limit the original jurisdiction of inferior federal courts. However, this court should maintain final appellate review. And those cases that you just listed, Your Honor, are cases that fit the mold of this type of final constitutional review. For example,
But we should have just said in Obergefell and Troxel, to your view, the trial court had no jurisdiction. End of story.
no, Your Honor. Respondents note that Obergefell does not neatly fit the mold of Troxel, Lawrence, and Loving versus Virginia. However, Troxel, Lawrence, and Loving versus Virginia were cases that were filed in state trial court and then appealed to the highest state tribunals and then granted certiorari by this court by means of 28 USC 1257. And so this
Obergefell
court,
is the most recent case. So tell us how you say it doesn't fit the mold. Explain to us why then we have the jurisdiction in that case.
yes, Your Honor.
Obergefell can be distinguished because
Although it was a case concerning domestic relations generally, and that was filed in the federal district court and then appealed all the way to this court, there are two distinctions to be made. The first is that Inc and Brandt redefined the exception narrowly in 1992. Obergefell was heard in 2015, and the relief that the plaintiffs were seeking in that case does not fit within the mold of the definition of the exception as defined by Inc and Brandt. The Inc and Brandt court defined the exception as only including cases where the relief sought would be the issuance of a divorce, alimony, or child custody decree. Plaintiffs in Obergefell did not consider or did not seek the issuance of even a marriage decree, let alone a divorce, alimony, or child custody decree. Therefore,
But how is it different from this case? So Obergefell, the issue of same-sex marriage.
And petitioners are arguing there was a constitutional right to same-sex marriage. In this case, the petitioner is arguing equal protection of the law. Why is it different? Why should a federal court be deprived of jurisdiction to rule on a question of equal protection of the law or equal protection or any other federal constitutional right? I guess I'm trying to understand the policy rationale behind your argument.
yes, Your Honor, there are federalism concerns behind leaving adjudication of these domestic relations disputes to the state courts. And first is a parity argument.
Why? I mean, state courts address federal constitutional questions all the time.
You're right, Your Honor. State courts are presumptively competent to adjudicate matters of federal constitutional law, as this court held in Taflin versus Levitt as recently as 1990. And so the parity argument to be made is that state courts are undeniably better at adjudicating matters of family law. They're structurally better equipped. Almost 2/3 of states have special family law courts that hear only these types of matters.
And I'll stop bothering you here in a second.
But why under your argument can't we just flip it and say that federal courts are better at deciding federal questions?
State courts are better at adjudicating matters of family law. They're equally as well equipped to handle matters of federal constitutional law.
And why can't you say the same about the federal courts?
Because it's undisputed that federal courts are not as well equipped to handle matters of domestic
I
relations.
suppose, with all due respect, I would dispute that.
I think any federal judge is equally capable of researching state law just as they are researching federal law. We have really good law clerks.
Your Honor, respondents point to a parallel situation, which is that in other situations, such as when this court exercises Burford abstention, this court has found that where final constitutional review is available, intervention of federal courts is not necessary for protection of federal rights. And that's much the same here, Your Honor. State courts are presumptively competent to adjudicate these types of matters. And this is a result of the Madisonian Compromise, the compromise at the Constitutional Conference that left Congress with the permissive power to create inferior federal courts, but did not mandate their existence. And so because inferior federal courts do not have to exist, citizens have to be able to adjudicate and vindicate their federal rights somewhere. And that place is often state courts.
Thank you. Sorry to take so much of your time.
Furthermore, Your Honor, applying the domestic relations exception across subject matter jurisdiction promotes democratic accountability. This court has unequivocally stated that the regulation of domestic relations is an area that has long been regarded as virtually an exclusive province of the states. Applying the exception to federal question jurisdiction is the only way to respect these state-level democratic processes that have developed through hard-fought battles in state legislatures to create law that is more in tune to constituents, arguably more than any other. State legislatures are the proper place for policy debate over these matters. Meanwhile, state courts are the proper place for adjudication of these matters. Applying the exception to federal question cases allows the creation and existence of policies to remain in the state's domain, subject to democratic processes far more attuned to local realities. State judges are usually selected or retained through popular election. In fact, only 7 states appoint judges without any form of popular election at all. And so if state judges interpret the law in a way that is contrary to the moral values of the constituents, there is a way to replace these judges. And so federal judges, on the other hand, are constitutionally insulated by life tenure and salary protection. Thus, not only are state courts bound by the rules that state legislatures enact, state courts are accountable to the people in a way that federal courts just are not. If inferior federal courts were able to unilaterally reopen the lengthy policymaking process by hearing federal question cases filed by disgruntled litigants, the democratic processes of self-governance would be undermined. Your Honor, I would like to go back to a point about Obergefell because respondents were never able to distinguish it fully. There is also a threshold matter issue there, which is that plaintiffs were challenging a statute on its face, the constitutionality of a statute on its face. Whereas in this case, plaintiffs and petitioners are seeking relief, specific relief, which is the issuance of a fit and proper person certificate, which is for all intents and purposes a child custody decree within the meaning of 18.
So tell me about why that is, and where's the limit?
Tell me why, for all intents and purposes, this is a child custody certificate. I noted in your brief, you said the exception squarely applies, and then you said it's the functional equivalent. I guess I view squarely applies and functional equivalent as different things. So help me understand why the exception applies here.
Your Honor, the exception applies here. The considerations are largely the same between issuing a fit and proper person certificate and a child custody decree. And that consideration is whether or not the person who is applying to take care of a child can actually effectively take care of the child. So the role of the court is the same in determining both. When considering whether or not to issue a fit and proper person certificate or a child custody decree both, this court must look into whether or not the person applying to take care of the child can give them food, can give them shelter, can give them love and affection. And so respondents asked this court to adopt the Seventh Circuit's approach to this, which is that the subject of domestic relations, including adoptions, is the primary responsibility of the state courts.
Well, let me ask you a question. This goes to the reach of your argument. What if we're dealing with an express
child custody decree, and the evidence shows that custody decrees are never given to African American parents? Are they, in that particular case, is someone barred from the federal court?
Your Honor, in this hypothetical, is this across all states, or is this just in one state, or?
Any state. Pick a state. So your argument, I think, would be, well, it's a child custody decree. You got no federal question jurisdiction.
Yes, Your Honor.
I'm struggling with why. I mean, if it's a clear racial discrimination, equal protection claim, why would you not be allowed to file it in federal court?
Your Honor, as previously stated, state courts and state family law courts are presumptively competent to adjudicate these matters of federal constitutional law. Thus, they should be left to the states. And the situation that you are describing is rare.
I think it's parallel to this case. We're not going to allow, a gay man to have a child. I mean, I think it's directly analogous.
Yes, Your Honor. Respondent's position is that this court is creating a rule that will affect more than just this case, and it would be more prudent to leave these matters of domestic relations to the states because they are better equipped to adjudicate them, and because they are equally as well equipped to adjudicate matters of federal constitutional law. However, as previously stated, this court will maintain final constitutional review over those cases if there is a unique situation where state courts have shown that they cannot adjudicate these matters in a fair and competent way. And again, respondents would point to cases such as Trujillo versus Granville, Loving versus Virginia, and Lawrence versus Texas, where this court did step in and exercise its right of final constitutional review in those issues. Your Honor, returning back to the constitutional language, the statutory language that precludes federal courts from exercising jurisdiction over these types of matters. First, Congress intentionally included the preclusive statutory language at common law and inequity in its original grant of federal question jurisdiction, just 17 years after the Barber Court decided that the language was preclusive and limited the jurisdiction of federal courts in the context of adversity jurisdiction. Second, this preclusive statutory language remained present in both jurisdictional statutes until 1948, when the key language at common law and inequity was replaced by the language all civil actions. Note that at the time Inkenbrand was decided, the language of the statutes was the same. Both 1331 and 1332 began with the language all civil actions. It makes little sense to argue that Congress implicitly ratified the exception in one of the statutes containing that language, when the key language of both statutes remained identical both before and after the 1948 amendments. It is only logical to conclude, therefore, that the exception was understood to encompass both diversity and federal question jurisdiction by the time that the statutes were amended in 1948. Thus, when Congress revised the diversity and the federal question jurisdiction statutes, it intended that the statutes would continue to exclude domestic relations disputes from the scope of federal jurisdiction. For the aforementioned reasons, this court should affirm the 14th Circuit's dismissal of the case for lack of subject matter jurisdiction. Thank you.
Thank you very much, Ms. Robinson. Thanks for your patience with me.
Mr. Sandhu,
You have 2 minutes of rebuttal.
Your Honor, if I may proceed.
You may. Thank you.
Your Honors, I have 2 points to make in the letter. The first has to do with a point that Justice Gabriel touched on, and one that my opposing counsel failed to square with the reasoning here, which is the issue of democratic accountability. Sex discrimination is not a policy the states are entitled to adopt through their legislators or push down upon their constituents and enforced by the state courts. The policies at play, the policies underlying domestic relations disputes, will always lie with the states. It is their power under Article 1, and it is not something we are asking the federal court to stray into here today. The only thing that a federal court and a federal judge would have to decide on remand is whether the respondent improperly relied on the petitioner's sex in making the final determination. We are not asking the federal court to make some of the same de novo considerations that a state actor would make, and we are not asking them to in any way step in for the legislator and make policy determinations, only to ensure that the individual's constitutional right against sex discrimination remains strong in this country. Now, secondly, are the 2 purposes that normally moat the domestic relations exception, just to quickly say that neither are here today. The first is the issue of logistical impracticability. It is thought that extended control of state actors, as would come with certain domestic relations disputes, is outside of the province of federal judges. This case wouldn't involve any extended control. It would simply involve the one-time issuance of a fit and proper person certificate. This wouldn't involve any control of state actors for an extended period of time, nor ask federal judges to rely on undeveloped channels of communication. Now, finally, before my time's up here, it is surely not outside the expertise of federal judges to inquire into whether an individual's constitutional rights have been violated. And for these reasons, the purposes of the DRE are not served here. We ask you to reverse the 14th Circuit and remand this case. Thank you.
Thank you, Mr. Sandhu. The court will now go on to the second issue, which is the applicability of the actual malice standard. Once again, the petitioner will have 13 minutes, and then the respondent will have 15, and then we'll go back to the petitioner for 2 minutes on rebuttal. I think Mr. Chin, you're up.
Good afternoon, Your Honors, Honorable Chief Justice, and may it please the Court. My name is Paul Chin, and I represent William Bohemia, petitioner. Mr. Bohemia requests that this Court reverse the decision of the 14th Circuit below and hold that the First Amendment does not require him to plead actual malice in order to make out a claim for defamation. First, because Gertz explicitly limited the scope of the actual malice standard, and this Court should not overturn its precedent. Because second, an extension of the standard is an unworkable solution that will lead to waste of judicial resources. And third, because limited purpose public figures are more similar to private individuals than to general purpose public figures or public officials in the context of non-germane defamation. The question of whether the actual malice standard applies is a question of law that this Court reviews de novo. The actual malice privilege is an exception. As a general rule, the First Amendment does not protect false statements of fact that cause legally cognizable harm. This Court has gone so far as to say that false speech has no constitutional value and thus is not protected. The actual malice standard that states must prove that the defendants had knowledge or reckless disregard for the falsity of their statements was created by this Court to protect debate on matters of public importance, but it's only a narrow exception. Respondents are now asking this Court to make the actual malice standard the exception that engulfs the rule, that demolishes the distinction between those who are covered by the standard and those who are not. But it does not extend to respondents' false and unfounded allegations concerning Mr. Bohemia. First, Gertz held that the actual malice standard is limited in scope. The Court there made two different types of distinctions. The first was between private individuals who fall under the general rule that false speech against them can be regulated. On the other hand, were public officials and public figures who fall under the exception to the rule, that speakers who criticize them.
Counsel, can I just stop you there? So you concede that your client is a limited purpose public figure, correct?
Your Honor, in the briefing, Mr. Bohemia, or petitioner, advanced argument that he was not a limited purpose public figure, and he stands by it. However, and he also argued in the alternative that even if he is a limited purpose public figure, the actual malice standard does not apply. At this point, we're only advancing the alternative argument and we are conceding yes.
So you are conceding?
Yes, Your Honor.
Okay, so then that has to mean something, doesn't it?
Yes, Your Honor.
And help me understand that. I mean, you're saying the world is divided between public and private, but you just conceded that your client is a limited purpose public figure, so that has to have some ramifications, doesn't it?
And that goes to the second distinction that Gertz Court made between general purpose public figures who are so famous and so notorious that they can influence how people think and behave, and thus they can shape public conversations and public policy. And for this reason, they're considered public figures for all purposes and in all contexts. However, limited purpose public figures have no such power and have no such fame. They would be private.
Excuse me, counsel, but in today's day and age of YouTube influencers,
How is it that a private individual doesn't have, on some level, the power to control the public narrative about themselves?
Your Honor, the issue is the effectiveness of their ability to combat defamation. Now, even in the time of Gertz, back in 1974, petitioners or defamation plaintiffs were able to go stand on the street corner and yell and utilize a self-help alternative in order to combat defamation. They could always write letters to editors. They could always try to seek interviews on national television or national radio, or write letters to national newspapers. So they always had that possibility. They always had a way to combat. The only question was that method effective? And the same is true in the modern age. Anyone can send a tweet out. Anyone can make a post on social media. The question is that effective?
But in this case, your client knows how to be effective, right?
At least in regards to the Barbara program and the bar examination, he's mustered those resources in order to make an impact on a particular issue. So aren't those resources available to him here?
Purpose public figures have thrust themselves into the forefront of a particular public controversy. And especially here, Mr. Bohemia, he does have 6,000 Twitter followers, many of whom are legal journalists. However, the radio station where the defamatory statements were made had 3 million listeners. He cannot combat them effectively, especially because he's not only alleging harm to his professional reputation, but also to his personal life, to his relationships, to his standing in the community.
So are we really to count how many listeners or in terms of access, they had 3 million versus 600. What if, they had 610 and he had 600? I'm troubled if that's kind of the standard we would adopt.
Petitioner is not asking this court to make the determination, just not to assume that limited purpose public figures, any of them, have the ability to effectively combat defamation for issues outside of their sphere of influence.
Why shouldn't we say, as Justice Hyde was suggesting, that a public figure is a public figure? I have to say I'm a little surprised you conceded he's a public figure or a limited public figure, but wouldn't that be an easier rule? If you're a public figure, there are First Amendment concerns and you're subject to credibility challenge and the like.
No, you are. Now, it's tempting to think that if this court does not require lower courts to perform a germaneness analysis and allows lower courts to dismiss more cases for failing to plead actual malice, that it can reduce litigation and save judicial resources. But our legal system is far more complex than that. Importantly, the germaneness inquiry is usually one that is easy and efficient for courts to make.
So tell me the test for germaneness.
You've said it in a brief
few times it was easy. I'm not so sure.
Help me out.
Courts simply need to look at the defamation, look at a public controversy which gave rise to that defamation, and determine the nature and extent of an individual's participation in that controversy.
Does that, as the respondent, I expect to get up here and argue that it gets us into content-based issues, and we have to review the content of speech.
How does that not involve us in First Amendment concerns we may not want to be involved in?
This court has always accepted that certain content-based distinctions are allowed, that certain special categories of speech can be discriminated based on their content. And it has always accepted that false speech and defamation is one of those. In RIV versus City of St. Paul, this court announced a general rule that content-based distinctions within those other ones are generally prohibited. However, it also announced an exception to that general rule, and that is the special virulence exception. That is, if the reason, the purposes for instituting that secondary or that tertiary content-based distinction that is within the other content-based distinction, then the statute did not violate the First Amendment. In this case, the reason why the First Amendment does not protect false speech is because it is of low constitutional value. It does not help us in our democratic self-governance. It doesn't help us figure out the truth or to hold our government accountable for government actions. Additionally, false speech can cause great harm to reputation. It can harm our livelihoods, it can harm our relationships and our standing in society. This court has recognized that the protection of one's reputation is part of the essential dignity and worth of every human being. And the reason why the actual malice standard applies in a limited fashion for limited purpose public figures, and the reason we make that distinction is exactly the same, in that this speech, this private speech about Mr. Bohemia, not about his advocacy for the New Amsterdam bar exam, not about his company, but about his private life, is of very low constitutional value. It doesn't help us in democratic self-governance, especially because it's false. Additionally, he doesn't have the ability to combat it effectively. It harms him a great deal, and he can't fight back. And that's exactly why the second content-based distinction was put in place. Returning to the extension of the actual malice standard, crucially, the germaneness inquiry is cabined to a narrow universe of facts. Again, courts only need to look at the defamation, the controversy that gave rise to that defamation, and the nature and against limited purpose public figures. It would in effect be inviting defamation defendants to make plaintiffs into limited purpose public figures for any reason at all. And crucially, because there's no germaneness inquiry, that analysis would be infinite. there will be no limiting principle to cabin the scope of discovery or litigation. Courts have found individuals to be limited purpose public figures for a wide range of issues, anything from being amateur athletes to being victims of a crime. In Holt v. Cox Enterprises, a lower federal court found that all amateur college athletes were limited purpose public figures for simply participating. And if this court were to extend the actual malice standard, it would hold that defamation against these individuals is fair game, and they have no way to respond. In Hobbs v. Pastar, a lower federal court held that a criminal suspect who spoke to the press to defend himself from the criminal allegations was a limited purpose public figure. And again, if this court were to extend the actual malice standard, it would hold that any defamation against him for the rest of his life is fair game. In Street v. National Broadcasting.
Let me ask you, just exploring the reach of
your position. So if Mr. Bohemia spoke out on Barbara or some issues relating to his business for which he had followers, is he then subject to criticism? This, if somebody then goes on that he's a fraud, he's not any bodybuilder or anything else, is he a limited purpose public figure for that purpose?
Yes, Your Honor. Because it concerns his work with Barbara and his advocacy concerning the New Amsterdam bar exam, that defamation would be germane and would not be held to the actual malice standard. Instead, they would only be held to the negligence standard of the New Amsterdam statute. Additionally, in Street v. National Broadcasting, the Sixth Circuit held that a victim of rape who spoke out about her assault was a limited purpose public figure. And if this court extends the actual malice standard to cover all defamation against her, for the rest of her life, she is vulnerable to defamation regarding anything about her life. And the issue here is not only that an extension of the standard is unjust towards these individuals, but also that courts would have to make good faith determinations about these issues all the time. Defendants would be invited to scour the lives of defamation plaintiffs to figure out if there's any reason at all, any public controversy that they're involved in, to make them limited purpose public figures, even when the defamation is completely unrelated to that reason. Whether they ever played amateur sports, whether they were ever suspects of a crime, whether they were ever victims of the crime. And this would lead not only to an unnecessary invasion into defamation victims' lives, but also to a waste of judicial resources. Lower courts should not have to make these unrelated determinations. Courts should reject respondents' proposal. It can only lead to extensive discovery, prolonged evidentiary review, evidentiary hearings, and a waste of judicial resources. This court should keep the germaneness inquiry to maintain the focus and the scope of the litigation on a manageable set of facts. Mr. Bohemia's work with Barbaro and his advocacy concerning the New Amsterdam bar exam do not raise a shield for respondents here to hide behind and to protect them from the consequences of their defamation. For the aforementioned reasons, Mr. Bohemia requests that this court reverse the decision of the 14th Circuit below and hold that neither the domestic relations exception nor the actual malice standard apply here. Thank you, Your Honors.
Thank you, Mr. Sandhu. You have 2 minutes for rebuttal. Mr. Hill. You may proceed.
May it please the court. My name is Danielle Trujillo on behalf of respondents Nicola, Magnussen, and Doyle Media Incorporated. Your honors, we are here today to respectfully request that this court affirm the 14th Circuit Court of Appeals order granting respondents' motion to dismiss. Even if subject matter jurisdiction is proper, we request that this court remand to the district court with instructions to apply the actual malice standard to all limited purpose public figures, regardless of the subject of the defamatory misstatements.
Well, isn't that just such a broad rule? Why have limited public figures anyway? I mean, why have a separate category if they're just treated like public figures?
Yes, Your Honor. Upon recognizing that the logical extension of applying the actual malice standard to all limited purpose public figures is in effect to treat limited purpose public figures exactly the same as general purpose public figures, this court has the opportunity today to reanalyze Gertz in the view that
you want us to hold Gertz was wrong.
There are two options here. First, the court may apply the actual malice standard to all limited purpose public figures and reject petitioner's request to adopt a subsequent germaneness or relatedness standard. Secondly, yes, Your Honor, finding that the logical extension of applying the actual malice standard to all limited purpose public figures is in effect to negate the category of limited purpose public figures altogether, this court has the opportunity to end that needless distinction in lower courts between determining when someone is a limited purpose public figure versus when they are a general purpose public figure.
So tell us why it's needless. Let's take one of the examples Mr. Shin gave. A rape victim is out there speaking out about, what happened to her and perhaps the inequities in the legal system. Is she subject, by nature of that, to all manner of defamation, challenging her credibility, attacking every part of her life?
No.
Why shouldn't there be a distinction between someone like her and, say, a president of the United States or a senator, someone who's a public figure for all purposes? Aren't they in a different spot?
Your Honor, undoubtedly, the case-by-case approach in determining, one, when someone is a limited purpose public figure, and two, then determining when something is germane or related to the reason for which they are publicly known, better protects individual and plaintiff's interest.
But I thought your position is we should get rid of the limited public purpose figure. You're a public figure or you're not.
Yes, Honor.
And so I'm concerned in the example in the rape case, that woman becomes a public figure for all purposes under your position. And I'm a little concerned about the limits, so help me with that.
Yes. So nevertheless, assuredly, the Gertz Court itself was concerned that judicial ad hoc justifications and determinations of who was a limited purpose public figure and who would be a general purpose public figure would lead to uncertain outcomes and uncertain expectations. That prediction came to fruition. Here, as petitioner aptly mentioned, media defendants do not know when someone will be determined to be a limited purpose public figure. They are unable to predict when actual malice standards will apply, when courts will apply the actual malice standard. This unpredictability censors the media because they are unable to predict, and in the worst case scenario, they may cease to speak on issues of public import.
What's the basis for your statement? What in the record supports that?
While there is nothing in the record explicitly, it is important to note that respondents, Doyle Media Incorporated, only have 3 full-time employees and make less than $1 million in revenue a year. While assuredly they did have 3 million listeners that day, they simply cannot afford to buy and protect themselves with the libel insurance if they were to be subject to endless suits by any plaintiff.
Well, again, why would it be you're talking
Very general. Why would endless suits? Why wouldn't the rule that the petitioner is advocating for simply encourage media companies to get it right, to not take a risk on the facts, to make sure they double check the facts? Why is that such a bad policy? If you're not sure, don't say it.
Your Honor, in making content-based distinctions in the category of defamation, courts have always found that it is important to balance the interests of the individual as well as the public and the media. The public has a right to receive an uninhibited, robust, and wide-open public debate.
Let me flip the argument on you. I apologize to you for
Taking too much time. Wouldn't your argument silence people in the petitioner's position? Somebody who fears their life is going to be exposed now to the media if they speak out on a public issue may choose not to speak. Why doesn't the policy argument cut the other way?
Your Honor, the petitioner's description of the Gertz Court's analysis for determining when someone is a limited purpose public figure is correct, but it is incomplete. In Gertz, the court found that someone may be a limited purpose public figure. However, it's important to note the Gertz Court never used the 4 words limited purpose public figure. These have been subsequent circuit-made distinctions defining them as such. But however, when someone has thrust themselves into a particular public controversy, they may become a limited purpose public figure because they thrust themselves into that controversy in order to influence the outcome of that controversy.
So what controversy did
The petitioner thrust himself into.
In this case, it's undisputed that Petitioner is a limited-purpose public figure by means of his involvement in the public promotion of his company, as well as advocating for change on behalf of the New Amsterdam.
So why do the comments at issue have anything to do with that?
Yes, Your Honor. Not only do the comments illustrate that they may be germane, but statements about personal characteristics have an impact on the public determining when someone is a figure of credibility. Limited purpose public figures voluntarily assume the risk that the public may be interested in statements or facts, characteristics regarding their credibility. To begin, in extending the New York Times actual malice standard to public figures from public officials in Curtis, this court recognized that for all intents and purposes, public figures and public officials are one and the same. In Garrison, in 1964, before Gertz was decided, this court held that statements regarding a public official's personal characteristics were relevant to the public's discourse because they were able to determine when something was about the figure's credibility. Finding today that this category of limited purpose public figures leads to uncertain outcomes, and finding that if we were to eliminate that category, we would have predictability in lower courts. Respondent requests and suggests that this court look to the court's holding in Garrison to find that statements about personal characteristics are relevant to the public's discourse about whether a figure is credible. As a limited public figure known for the advocacy of his product that sold things relating to moral and legal and ethical products, the accusation that Petitioner engaged in the solicitation of a prostitute, thereby breaking presumably the law in New Amsterdam, fundamentally affects the public's consideration of whether he was credible to assume that role of the public relations executive of Barbaro. By holding himself out to be an expert in legality and moral ethics of this bar exam company, Petitioner assumed the risk that the public would be interested in these allegations. Not only do these statements regarding his credibility illustrate the zone of defamatory publicity Petitioner may have assumed, but they also illustrate how these statements were related to the reason for which he was publicly known. We've been discussing these further content-based distinctions and discriminations, so it's important to realize that in adopting a germaneness test, as circuit courts have in the 4th, 5th, 7th, 11th, and DC circuit, these courts have been adopting content-based discriminations that are rendered unconstitutional by this court's holding in RAV. This court has long held that content-based distinctions are presumptively invalid. This holding came in 1992 by this court in RAV after many of these circuit courts had adopted these germaneness tests.
So help me understand, where is the content discrimination
in the germaneness test?
The content discrimination in the germaneness test is that you have to look, read, or see the speech to determine whether it is related to the reason for which a limited purpose public figure.
But it doesn't require a court to opine on the value of the speech or anything about the substance of the speech.
Is it related to what makes the person a limited purpose public figure?
Something is labeled to be content discrimination when it does not pass the RAV special virulence exception.
Discrimination deals with, you can't speak. In this particular case, the result of whether it's germane or not is just defines what standard we apply. Isn't that different?
No, Your Honor. It is not different because, well, to take it a step back, assuredly the government can, consistent with the First Amendment, regulate in the category of defamation. However, in RAV, this court held that further content-based distinctions, regulations, court-created tests are only acceptable when they are enacted for entirely the very reason the entire category of speech is prescribable to begin with. The distinction between private individuals and public figures, as held by this court in Gertz, is a content-based distinction that is valid under this special virulence exception because it was adopted for entirely the very reason the entire category of speech, defamation, is prescribable. This category of speech, defamation, can be regulated because the court found that some amount of falsehood is inevitable. Therefore, we must protect some falsehood in order to protect the speech that matters. The germaneness and relatedness tests adopted by circuit courts do not pass the special virulence exception because they were not adopted to protect falsehoods or speech, but to protect individuals, as you have mentioned. Therefore, because they are not adopted for entirely the very reason the category of speech defamation is prescribable, they are unconstitutional and impermissive.
Counsel, can I just ask you then, do you think that Gertz has the germaneness exception in it? Is that why you're arguing that Gertz has to be overruled?
No, Your Honor. These circuit-created germaneness and relatedness tests.
Well, I know the circuits did that, but I'm wondering if you could just read that into the case because the facts of the case were germane, correct?
Yes, Your Honor, and I believe Petitioner's argument on this point is that there was a germaneness inquiry because you had to look at the nature and extent of the public controversy to determine when something may have made someone a limited purpose public figure. But again, going back to that analysis in Gertz, and perhaps this is a very strict textualist argument, but never once in that analysis did the court use the words limited purpose public figures. At the time, they did mention that there were a category of people who had not thrust themselves so far into the public eye that they would be known for all purposes. However, the court in Gertz...
Is limited purpose public figure accurate to describe that category?
No, Your Honor. As circuit courts have since, and this court has in a motion for summary judgment affirmed that the analysis does include a limited purpose public figure category. However, the curtain court, Gertz, explicitly stated that those who had thrust themselves into the forefront of a particular controversy invited the same amount, if not a little less, attention and comment. Today, the internet allows nearly every individual access to the public forum, especially those who have invited attention and comment by thrusting themselves into the front of a particular public controversy.
Well, so are you advocating that every person should be
A public figure?
No. Seeing the court's hesitation and with certain hypotheticals of how often would an individual need to tweet to necessarily become a public figure, and assuredly there is a difference between someone who has assumed office or a celebrity such as Angelina Jolie, then there is from Petitioner in the case at hand. Respondents suggest that this court adopts the Gertz court's categorization that someone would be a public figure when they had thrust themselves to the forefront of a particular public controversy in order to influence the resolution of the issues in that controversy with a limiting factor. The limiting factor being that they have achieved a sense of fame or notoriety within that controversy. Therefore, assuming this court's concerns about essentially everyone being able to be labeled a public figure.
Could you apply, I'm sorry.
Can I just ask one more question? I'm sorry. So can you apply your tests to the facts here?
Here, Petitioner had assumed a role of fame and notoriety in the public controversy for which he was publicly known. He was known, and it was conceded by Petitioner that he is a limited purpose public figure by means of his public promotion of his product, as well as advocacy for change on behalf of the New Amsterdam bar exam. He had achieved a role of fame in that controversy. Therefore, he is a public figure. May I conclude?
You may. Briefly, please.
Yes. For the foregoing reasons, Respondent respectfully requests that this court affirm the 14th Circuit Court of Appeals order and remand to the district court with instructions pursuant to your holding today. Thank you.
Thank you, Ms. Trujillo. Mr. Chin, you have 2 minutes.
Two quick points, Your Honors, on the potential chilling effects of the actual malice standard on small media companies. First is that this court has always rejected a distinction between media defendants and private individuals. Petitioner is not asking for a special rule to apply to media companies, only that the actual malice standard apply, and we hold these media companies to the same standard of common decency that we hold each other. We respect members of our community and not defame them. The second is that the New Amsterdam statute for defamation and many statutes, because of a ruling in Gertz, hold defamation defendants to a negligence standard, that they act in reasonable care. And so if there's concern about a small media company not having the appropriate resources to figure out the truth of the matter, we're not asking them to go back and extensively research, only that they exercise reasonable caution, use the resources that they have available to them to figure out if the facts that they are speaking are true or not.
I'm sorry, because I have to follow up on that. Are you suggesting that the reasonableness of one's conduct may be tied to the resources they have to invest in investigating?
Yes, Your Honor. That if someone doesn't have the resources to extensively and thoroughly investigate whether something is true or not, then courts should not require them to do so, only that they exercise reasonable care to try to figure out if it's true. And if they don't have the resources to do extensive research, then the court's not required. For the aforementioned reasons, Mr. Bohemia respectfully requests that this court reverse the decision of the 14th Circuit.
Thank you, Mr. Chin. The court would like to thank all counsel for their superb
arguments and also their superb briefs. The court also would like to thank Ms. Hannah Rubashkin for volunteering at the last minute to serve as our timekeepers. Thank you, the court's clerk. The court is going to take a very brief recess and deliberate. I understand we need to choose a very difficult decision to choose a winning team of the best oralist. I don't envy us for this very difficult decision, so the court will be in recess briefly and then we'll come back and announce our results.
My video went off. Yeah, we'll get your numbers.
Questions that he's going to provide. Okay, guys, so they're going to try and set up a Q&A for us. Let me see. I don't know. Okay, guys, we have some questions. So if you want to come up to this mic. So the first is, how long did it take you guys to prepare for this?
Hi, I'm closest to the mic, so I will answer. This was a long process because we had preliminary rounds almost a month ago. So we had to write a brief, and then we had to practice for prelim rounds, and then we did prelim rounds, and then once we made it to the finals, then we had to rewrite our briefs, especially Danielle. Big shout out to Danielle because she had to write a whole new brief. She's the only one, so she's amazing, as you guys just saw. But we had to rewrite our briefs, and then we had to redo all of our practices, basically. So it was a lot of hours. It's been the last 2.5 months straight. Yeah, so I think we all put in a lot of effort, and I mean, in the end, you just kind of have to band together as the 4 finalists and practice together. So we all put in equal effort, I think.
Okay, I'm going to try and unfreeze this screen because apparently it's just frozen on me, which is, no one wants to see that. Let's see if this works. Okay, there you go. It's working again.
don't want to know what I'm going to
Okay,
say.
for the final oral, let's read it out. You have a nice, slow pace to your speech. Assuming that didn't come naturally, do you have any advice for oralists who find themselves speaking too quickly?
If I could have saved some of my friends, I would have. I was a big drama nerd in middle school, so that is what came from mine. But also, I just find that the faster I go, the worse I sound, and I sound like I'm spiraling. So if you see me going particularly slow, that's actually that's like when I have something memorized the most, because I actually know what I'm about to say. So memory.
Okay, next question is, any of the judges or justices,
Deja?
we can just repeat the questions.
Oh, okay. Repeat questions? Yeah. Okay. So the question asked, I'm back again, was whether any of the judges or justices in this case threw us off guard. I had a few questions today that I have not received before through all of our rounds of practicing, which I didn't anticipate because we've had so much practice in so many rounds. And then just the ability for a single jurist to keep going and going and going was something new, because usually our classmates let off a little bit, but it was great practice.
Okay, I'm going to call in the question. Why should someone do
Tell them, Paul.
Why should someone do Moot Court? Because it's awesome. I find it really fun. I like doing research. I like writing briefs. I'm a nerd. I like getting up and talk because I'm argumentative and conceited. But I think it's a great learning experience. You learn a lot about yourself. No, tell you. Because I like it.
So about a week before the first round of this, I had a motions art class, and the judge who teaches that class reamed me for like 15 minutes in front of my classmates about speaking too quickly. And despite what you heard me do today here when I was a little nervous, I've actually developed the ability to speak a lot slower during these arguments. And assuredly that needs more work in situations of stress. But like the hard skills that you get out of this can actually be refined within a matter of weeks because you're doing arguments so often. So I really recommend it for people who, like myself, either speak too quickly, or if you just want more experience writing in general, I recommend it.
I like doing moot court because I like writing briefs, and it's really fun to research like a new area of law that you've never even heard about, and then become an expert in it in like a matter of weeks, and then try to convince other people why you're an expert in it. It's really fun. I definitely like the writing more than the argument part, but even if you're less inclined to speak in front of people like me, you can develop really useful skills from it. So I recommend it fully.
I guess one thing I would add, so my answer is not completely general, is a lot of law school, you're just reading and taking notes and briefing and listening. And so this is a really good opportunity to actually try to apply those skills and see if you've learned anything and see if you figure out how those skills would apply in the real world. So just if you want something that's more hands-on, more practical, where you can actually get up and speak instead of just read stuff, I think it's a good opportunity for that.
For anyone, what do you recommend one else? What advice do you have for one else as they prepare for law?
Hi, so the question was what advice we have for 1Ls as they prepare for oral argument. I know that in some 1L sections, like KJ's, Neil and my advice is to ask for help. I had no idea any of the language to use, like may it please the court. And yes, it is very formulaic and formulistic, and that's the language. So I didn't know that. And so just even listening to this today, now you know what it looks like. So you did good. You're here, and that was very helpful. So good job.
You all have great eye contact. How do you train yourself?
Memorize.
Okay, the question was, you all have great eye contact. How do you train yourself to do that? And my answer is, once you start getting asked questions, if you look down and break that, it can really screw you up. So it kind of just has to be like a natural like conversation with the judges. And when you look at them in their eyes, then when you are like making direct eye contact, you can like gauge their response to your question as well. So I think that making direct eye contact is really crucial to this. And for me, it takes me a little bit, like usually at the beginning of my argument, I'll just be like kind of reading, which is bad, but like you have your intro memorized, and then I kind of have like a section where I like look down and read. But this argument specifically, they pulled me off that really quickly. And so I just had to make direct eye contact with the judges so that I wouldn't freak out and die. And you have to know when to stop speaking because they will interrupt you. I don't know if you guys saw, Justice Gabriel was like really interrupting me and Danielle, but that's, that's part of it, so it's helpful.
I need a second think.
Okay, hi, it's me again. The question was, what moment in your argument were you most proud of? Or that was kind of what the question was. For me, I had a countdown clock of 13 seconds left, and I was still answering the question from one of the panelists. So I usually have a long conclusion and then a short one-liner. And for some reason, today was the day that I decided to make up a brand new short one-liner. And I actually think I liked it, but I'll black out and I really don't remember what I said. So hopefully it was good.
I think the proudest I was is when Judge Ide asked me why I used the word invent. Because my argument actually relies on me telling the court they lied 100 years ago, which is just not great. It's not what you want to do to the court. So I felt like I got around that decently well, especially because they're pushing me pretty hard. I'm trying to be honest about that.
I'd say probably just my intro, because I've been heavily rewriting my intro and the roadmap, especially even up till yesterday afternoon. So I've actually, in practice earlier today, I've been stumbling over the roadmap because I rewrote it. So the fact that I got through it, I was pretty proud.
There was a moment in my argument where Justice Gabriel was talking about like racial discrimination, and I kind of had to just double down on my parity argument, and I thought that it went well. So that was if I could choose one moment, is that it?
The question was, any tips for removing any quirks you have? And because we practice so much with each other, we all know each other's quirks and tics, and I promise you they were so much better today than they were 2 weeks ago or further back. So I think the biggest is just practice. The more times someone can tell you that you're doing it, the more times you can feel publicly shamed by it. My biggest one, I think, is saying respondents think or respondents believe, and then that kind of morphed into me just saying respectfully a lot. So sometimes you replace old tics with new tics, but it's just great to have ears listening to what your tic is.
I'll be short. My tic was hitting a pen on the table when I was making a point. which I thought was, like emphatic, like it was punctuational, but it just sounded like knocking everybody else. So I left the pen off the table. And it sounds stupid and simple, but doing little things like that, or just promising you won't lift your wrists from the edge of the lectern to stop yourself from gesticulating, it's really helpful.
Took your pen off. I was terrified. Drop it. I guess my biggest one that I've worked on is movement. At the pace, I like to readjust and stuff, so I've kind of forced myself to hold the podium and just stay right here and just be good about it. So. All right.
Yeah, we don't need to all rise.
All right. Are we still live streaming?
Yes, so thanks everyone for tuning in. We're going to announce the winning side and best oralist.
All right, so first of all, we took a long time because you all made this an exceptionally difficult decision. And I say this and I mean it very sincerely. If we could have the quality of all four of you in my court and all of our courts all the time, life would be really great. I hope you'll take time to sometimes watch some of the advocates we see. We see good ones, and sometimes we see ones who are not even anywhere close to the level of argument that you all did. So we'll announce the winners that we chose, and then we'll give you just brief feedback, and then we'll let everybody celebrate a little bit. So again, the decision was very difficult, but in terms of the best team, the court has unanimously decided that the best team was the petitioners. So tumultuous applause in the room. And then in terms of our best oralist, also an exceptionally difficult decision, we have unanimously agreed that our best oralist is Ms. Trujillo. And so congrats to all of you. We'll give you some feedback. Judge Brown, why don't you go first?
Go advocate by advocate or just, okay. I echo Justice Gabriel's comments. You all, we see a lot of oralists that don't compare to you. And so you guys should give yourselves big kudos. I know that it was a lot of work. I did this when I was in law school. I remember that. It's a lot of work. And it prepares you really well for the work ahead of you. So it's not wasted time. It's not just pretend. I mean, it's pretend, but it's not just pretend. It has application outside. So good job, you to all of you. Let me start. I'll just start left. Mr. Chin, you have a fun tick when you stumble over your words. You have a great smile. You like to flash it when you stumble over your words. I only mention that because sometimes we're not aware of the tics that we have. I talk a lot with my hands. If I sat on my hands, I would be mute. So I am aware of, body language when you're, and your facial expressions when you're arguing. But I thought you had excellent demeanor. I thought the flow of your argument went really well. And you transitioned in and out of your argument, in and out of answering questions really well as well. My only other note for you is if you have to concede, concede. Mr. Sandhu, I also thought that you did an excellent job. It's really challenging going first. I thought you did a really nice job being the first person to get up here and talk and sort of break the ice. I also thought you did a great job responding to questions. Your mastery of the law seemed really on point. I thought you could sort of recall those cases very quickly. And I thought that you had a really nice rebuttal in particular, because it was very responsive not only to the respondent's arguments, but also to the questions that we asked. And so I give you lots of props for that. Ms. Robbins, I think you got the hardest series of questions, and I think we all agree on that. The hardest series and the most of them sort of right in a row. So excellent job on maintaining your composure and responding, even though that's probably not where you wanted to go with your argument. And I thought you did a nice job sort of taking a pause and getting back to the argument that you had planned, even when that discourse with Justice Gabriel was over. I thought in particular your yes, your honors, and no, your honors were really respectful. I thought it's nice to get a solid answer to the question before you start explaining. And so I thought that was a really good thing for you as well. Try to maintain your energy as the argument goes on. Like I said, you got peppered with a lot of questions. And so just make sure that you end the argument with the same vigor that you started the argument. And then Ms. Trujillo, I thought also you did an excellent job. Your mastery of the material without referencing notes was pretty impressive to me. I saw you flip your page, but you wouldn't even look at it. It's like you knew where your notes were on the page without looking at them, and you didn't have to reference them, and that was really impressive. So nice job knowing the material. I think your argument, it was a challenging argument, and you did it in a straight-faced manner. I know some of my colleagues will have other specific comments for you about the structure of your argument, but overall I thought you did an excellent job keeping your cool in response to some challenging questions about the nature of your argument, and I thought you had really nice transitions between your arguments and responses to questions as well. So good job. It's probably more words than you needed. Sorry about that.
Well, I thought it was amazing. I just enjoy it so much, and I loved your presentations. I thought you worked so hard, and it was just very, very impressive. So I just have congratulations. Just some specific things, and I'll just start at this end. You're like, hey, Gertz is gone, and it just embrace that. I mean, if you're going to make that argument, you just go for it. And I think toward the end of your argument, you kind of brought it back to, hey, everything's different. So if you're going to make that really big argument, you have to tell us why this is a different world with internet. And you did do that, but do that sooner, because I can tell you, we're judges. You want us to overturn something, right? You need to back that up. But I just thought your demeanor was excellent. You answered questions just really, really, really well, and congratulations. I thought you had the hardest argument, and you were really, really, really peppered with questions. And what I wanted to say is that you recovered though. And you said, hey, listen, petitioner's asking you to interpret language differently. That's the same language. Or you return to your affirmative arguments, and kudos to you. That was excellent. Mr. Chin, I'm in the limited view seating here. Okay. Okay. I know. That's true. That's true. I thought, good job on the slippery slope. That is, you nailed the slippery slope. And I think that is one of the most effective things you can argue, and you just had that mastered. So that was excellent, because that really does make you think, where does the slope stop? And for you, it didn't, right? I mean, you just had case after case after case. So that was really excellent. And then I wanted to I thought your rebuttal was excellent too. You got to have a little bit of outrage, right? And you did, even though you have you've got a calm demeanor. I think on rebuttal, you were like, hey, listen, the state courts aren't here to protect discrimination. And I think that was just really, really, really effective. So, but you were all incredible, and I loved every minute of it.
Well, I'll keep this short, since you probably all just want to go out and have a drink somewhere at home, because you can't go anywhere. I did, by the way. You all were not on this email string, but I encouraged folks to, let's go have a celebratory dinner when we're allowed to, because you earned it. I'll just kind of go in the order in which you argued, because it'll be easier on my notes. And I could say the same for all four of you. Wonderful presence, wonderful eye contact, wonderful answering the questions, wonderful preparation. I would say that of all four of you, it was tremendous. Neil, I just, in particular, I mean, you have a really nice manner and really good presence, and don't lose that. I thought the answers were very good. I liked the rebuttal, but I won't repeat this on both of you. I can't tell you how often in this courtroom someone gets up there. We have three quick points of rebuttal, and then they talk for their 2 minutes on point one, and I'm poised to write points 2 and 3, and they never get there. I always say, rebuttal, you make 2 bullet points, and you both did a pretty good job on that. You know, if you're going to make rebuttal, make it count. But don't say 3 points and then spend your whole rebuttal time on one of them. I think you both did that well. Asia, I'm sorry. I just, you know, and some of it in the competition, you just see how people react to hard questions. And I assure everyone, when we judge this, you know, we didn't decide it on the merits. I would say on the merits, I think you probably have the hardest argument in the room. And I was beaten on you. And some of it was a little bit on purpose to see how you would react. You did a great job. You maintained your poise, you maintained your calm, you didn't freak out. And that's really important, to hang in there when you get hard questions. You're going to get skeptical questions on a case, even when you're on the winning side. And I thought you did a great job. Again, great demeanor. I was impressed by how you hung in there, because I know I beat up on you pretty good. It was not personal. So let's see, Paul, I echo what my colleague said, also really nice manner, all that kind of stuff. You really answered questions very well, prepared for all the questions. And I also had made a note when Judge Brown said, beware, we all have our nervous tics. And if you just kind of slip up in language and you have some kind of tick, you're just calling attention to it, just let it go. I mean, I had trouble getting words out of my mouth here today myself. We all do that. For me, I'm from Brooklyn, New York. I had to write on the top of my outlines in every oral argument, slow down, because I would talk really fast. Just be mindful of it. But I thought you did a really nice job. And Danielle, I echo what everybody else said. You just great temperament, great eye contact. I also noticed you didn't look at your notes at all. And my perception is you actually got stronger as the argument went on. You just kind of, I think whether just you got more comfortable or whatever else, you just kind of got going, and you ended really, really strong. I also beat you up a little bit, and you hung in there in very hard questions, which I found very impressive. So superb job to all 4 of you. I know we need to get you out of here and celebrate. I really wanted to, you kind of get cheated here. You don't get a dinner, you don't get the crowd screaming, you know, and throwing stuff at you, you know, flowers at you, whatever else. But I wanted, we have a small token from the 3 of us for all 4 of you. It is a little journal with an embossed Colorado Supreme Court logo on this. It is a small token, but it's something we wanted to at least give you to acknowledge the fantastic job you did. I wish you all, all of us, we congratulate you all. We wish you all the very best as you complete your law school careers. And for all 3 of us, all 3 of us, I know, we look forward to having you in our courts. You will be a credit to the bar wherever you decide to practice law. So congratulations, everybody. And to everybody online, thank you for tolerating this. They're applauding wildly in Boulder. Great job.